Did you ever imagine that a question about air pollution could end up changing the way governments work? Now, that may be exactly what happened with the Supreme Court's opinion in West Virginia versus the Environmental Protection Agency. What started as a question of whether or not the EPA's plan to reduce carbon dioxide emissions from the electric grid was constitutional turned into a statement about the limits of discretion granted to the executive agencies. So we'll discuss that more next on the Constitution Study. Hello there, everyday Americans, and welcome to the Constitution Study. This is where we read, we study the Constitution. We teach the rising generation to be free. I am glad you could join me today. Now, I want to give you fair warning. If you are watching this on YouTube, I may not be here for much longer. I got my first strike, which means I haven't been able to upload for a while, but that's okay. I got this up here, but I got that strike for a video I did talking about the election in 2020, which apparently is information YouTube doesn't want you to have. So if you want to follow what I'm doing, if you want to get these videos, regardless of what YouTube does, make sure you follow me at constitutionstudy.com. I post these videos, I post the text version, you can always find it there. And hey, if you sign up for the newsletter and you check the little box, I will email you every time I release a new post. So give that a try. Now I'll talk more about the website later, but right now, let's get to this EPA case. The question before the court in West Virginia versus EPA seemed quite simple. Since the passage of the Clean Air Act 50 years ago, EPA has exercised this authority by setting performance standards based on measures that would reduce pollution by causing plants to operate more cleanly. In 2015, however, EPA issued a new rule concluding that the best system of emission reduction for existing coal-fired power plants included a requirement that such facilities reduce their own production of electricity or subsidized increased generation by natural gas, wind, or solar sources. The question before us is whether this broader conception of EPA's authority is within the power granted to it by the Clean Air Act. What was the EPA trying to do with their new rule to reduce emissions? The point, after all, was to compel the transfer of power generating capacity from existing sources to wind and solar. The White House stated that the Clean Power Plan would drive an aggressive transformation in the domestic energy industry. The EPA claimed the authority to transform electrical generation throughout the country. Now, was this a power Congress had delegated to the EPA under the Clean Air Act? Well, according to the majority of the court, no. Under our precedents, this is a major questions case. In arguing that Section 111D empowers it to substantially restructure the American energy market, EPA claimed to discover in a long extant statute an unheralded power representing a transformative expansion in its regulatory authority. It located that newfound power in the vague language of an ancillary provision of the Act, one that was designed to function as a gap filler and had rarely been used in the preceding decades. And the agency's discovery allowed it to adopt a regulatory program that Congress had conspicuously and repeatedly declined to enact itself. Given these circumstances, there is every reason to hesitate before concluding that Congress meant to confer on EPA the authority it claims under Section 111D. Not surprisingly, some of the justices disagreed with this assessment. Compare the majority's statement to how the dissent views the situation as written by Justice Kagan. As I have already explained, nothing in the Clean Air Act, or for that matter any other statute, conflicts with EPA's reading of Section 111. Notably, the majority does not dispute that point. Of course, it views Section 111, if for unexplained reasons, as less clear than I do. This is the true crux of the case. Who decides what a law means? Congress, who writes the laws, or the executive agencies that enforce it? Justice Gorsuch points out how the court goes about doing this in his concurrence. One of the judiciary's most solemn duties is to ensure that acts of Congress are applied in accordance with the Constitution in the cases that come before us. To help fulfill that duty, courts have developed certain clear statement rules. These rules assume that, absent a clear statement otherwise, Congress means for its laws to operate in congruence with the Constitution rather than test its boundaries. In this way, the clear statement rules help courts act as faithful agents of the Constitution. In other words, Unless there is a clear statement in the law to the contrary, Congress means for its laws to be enforced following the Constitution, not testing the boundaries of it. Now, since the question revolved around how the EPA interpreted the Clean Air Act, let's start there. But the agency explained, in order to control CO2 from affected plants at levels necessary to mitigate the dangers presented by climate change, it could not base the emissions limit on measures that improved efficiency at the power plants. The quantity of emissions reductions resulting from the application of these measures would have been too small. Instead, to attain the necessary critical CO2 reductions, EPA adopted what it called a broader, forward-thinking approach to the design of Section 111 regulations. Rather than focus on improving performance of individual sources, it would improve the overall power system by lowering the carbon intensity of power generation. And it would do that by forcing a shift throughout the power grid from one type of energy source to another. In the words of then EPA Administrator, the rule was not about pollution control so much as it was an investment opportunity for states, especially investments in renewables and clean energy. This view of the EPA's authority was not only unprecedented, it also affected a fundamental revision of the statute, changing it from one sort of scheme of regulation to an entirely different kind. It appears, in the mind of the EPA Administrator, when Congress said they were to improve the efficiency of power plants, that really meant protect us all from climate change. Furthermore, when Congress said to improve performance of the individual sources of electricity, it really meant to regulate the entire electrical grid. Now, as the EPA Administrator was quoted in the opinion, the Clean Air Act wasn't about pollution control, but investing in renewable energies. But is that what Congress included in the Clean Air Act? On EPA's view of Section 111D, Congress implicitly tasked it and it alone with balancing the many vital considerations of national policy implicated by deciding how Americans will get their energy. EPA decides, for instance, how much of a switch from coal to natural gas is practically feasible by 2020, 2025, and 2030 before the grid collapses, and how high energy prices can go as a result before they become unreasonably exorbitant. There is little reason to think Congress assigned such decisions to the agency. We also find it highly unlikely that Congress would leave to agency discretion the decision of how much coal-based generation there should be over the coming decades. We are confident that Congress could not have intended to delegate a decision of such economic and political significance to an agency in so cryptic a fashion. It appears the majority of the court does not agree with the EPA Administrator's assessment. They seem to think it is highly unlikely that Congress would give an agency discretion to determine how much coal-based electrical power there should be over the decades, and I agree, especially since Congress has repeatedly rejected the cap-and-trade theory in the past. Under our precedents, this is a major questions case. In arguing that Section 111D empowers it to substantially restructure the American energy market, EPA claimed to discover in a long-extant statute an unheralded power representing a transformative expansion of its regulatory authority. It located that newfound power in the vague language of an ancillary provision of the Act, one that was designed to function as a gap filler and had rarely been used in the preceding decades. And the agency's discovery allowed it to adopt a regulatory program that Congress had conspicuously and repeatedly declined to enact itself. So the court asked the EPA to show the clear congressional authorization to enact their new plan. Given these circumstances, our precedent counsels skepticism toward EPA's claim that Section 111 empowers it to devise a carbon emissions cap based on a generation shifting approach. To overcome that skepticism, the government must, under the major questions doctrine, point to clear congressional authorization to regulate in that manner. All the government can offer, however, is the agency's authority to establish emissions caps at a level reflecting the application of the best system of emissions reductions adequately demonstrated. The EPA could not show a clear authorization from Congress to implement a policy to force a nationwide change in how electricity is generated. For that reason, the court found for West Virginia, overturned the decision of the Court of Appeals, and sent the case back to court for further proceedings. Capping carbon dioxide emissions at a level that will force a nationwide transition away from the use of coal to generate electricity may be a sensible solution to the crisis of the day. But it is not plausible that Congress gave EPA the authority to adopt on its own such a regulatory scheme in Section 111D. A decision of such magnitude and consequence rests with Congress itself, or an agency acting pursuant to a clear delegation from that representative body. The judgment of the Court of Appeals for the District of Columbia Circuit is reversed, and the cases are remanded for further proceedings consistent with this opinion. 3 members of the court, Justices Kagan, Breyer, and Sotomayor, disagreed with the majority. Today, the court strips the Environmental Protection Agency of the power Congress gave it to respond to the most pressing environmental challenge of our time. Interesting how 3 justices claim that the court stripped the EPA of a power Congress had not only not specifically given to it, but had repeatedly declined to implement themselves. Climate change's causes and dangers are no longer subject to serious doubt. Modern science is unequivocal that human influence, in particular the emission of greenhouse gases like carbon dioxide, has warmed the atmosphere, ocean, and land. It's a good thing these justices are not scientists. There is plenty of scientific debate, not only about the severity of climate change, but how large a role humans play in it. And what does the severity of greenhouse gases have to do with what Congress has passed into law? The answer is absolutely nothing. What we see here are members of the court not only changing the subject, but claiming that the executive branch can enact laws not passed by Congress simply because the court believes there's a serious problem. The Clean Air Act was major legislation designed to deal with a major public policy issue. As Congress explained, its goal was to speed up, expand, and intensify the war against air pollution in all its forms. But did Congress give the EPA the authority for investment into certain technologies in an attempt to move electrical generation from coal to other sources? Well, first of all, Congress gave the EPA the power to regulate pollution, not carbon dioxide, which is a natural part of the ecosystem life cycle. But did Congress give the EPA the authority for investment into certain technologies in an attempt to move electrical generation in America from coal to other sources? Not even the dissent provided evidence that they did. The one question that I didn't see asked in this case was, did the Constitution delegate to the United States the power to control pollution, carbon dioxide, or the regulation of power generation? The answer to that question is definitely no. While the court said that Congress had not delegated to the EPA the power to create a cap-and-trade system or to regulate how electricity is generated in this country, no one seemed to ask this more basic question. Was this a power delegated to the United States in the first place? However, a fundamental statement was made by this opinion. Executive agencies cannot enact rules beyond the power specifically delegated to them by the legislation. It appears the EPA, along with most if not all the other executive agencies, believe they have the power to run the country. Not a very Republican way to do things, is it? A republic, by the way, is a commonwealth, a state in which the exercise of sovereign power is lodged in representatives elected by the people. To me, that is the biggest takeaway from this opinion. Who decides what the laws are? And by extension, what they mean? Is it we the people through our elected representatives? Or is it the unelected bureaucracy that decides our laws? So according to the Constitution, the president is to be sure that the laws created by Congress are faithfully executed within the confines of the Constitution. While it has been many years since the courts have followed that structure, I'm glad to see that they have in this case. West Virginia versus EPA is one of 3 cases this year where the court has placed the language of the Constitution and laws of the United States above precedent, tradition, and more importantly, perceived need. While the 3 justices who dissented in these cases seem more interested in seeing the government rule rather than following the supreme law of the land, I don't expect that to change much with the appointment of Justice Ketanji Brown Jackson. I can only hope that the court will continue this fidelity to their oaths to support the Constitution of the United States. It would certainly help decide if America is to rise again to be a republic or continue to devolve into an oligarchy. I know, a little case about pollution, in this case, carbon dioxide, which the EPA calls pollution, turns into a question of where the boundaries of an agency's power end. Can they do what Congress has not told them specifically they can do? Can they make it up as they go along just because it's important or not? It's a very interesting case and has the potential to have some very long-term after effects. Now, if you like this episode, you can find more. Yes, I'm on YouTube, Rumble, Twitter, where else? I'm on Truth Social, Gab TV, lots of places. But the best place to follow the Constitution Study is, well, at our website, constitutionstudy.com. Now, I've got a lot going on in the next few months. I still have my tour coming up. I've got dates in North Dakota, Idaho, and Wyoming coming up. I'm trying to get some dates out in California, up near Pennsylvania in the Northeast, maybe down in Florida and Georgia. But I need your help. You see, while I've got a lot of these dates set up, I work with a local person on each and every one of them. So I'm looking for people in these locations around the country that will help me set up one of these events. Now, if you're willing to consider hosting an event, having me come speak to your group or your event, well, check out the website, constitutionstudy.com/tour. You'll find the dates where I'm speaking. You'll find information about the tour dates, and you can fill out a form to get in touch with me about doing an event in your area. Again, I need your help to do these, to put these on. I can't do the work all by myself. I don't know most of these places, but I'm looking forward to meeting you and to seeing the beautiful parts of this country that you live in. Now, I'm about to wrap up our online study. We have been through the entire Constitution, the Declaration, the Bill of Rights, the whole thing. I've had a great time, and those who have joined me seem to have had a pretty good time too. Now, I'm going to take a hiatus for a while, but I am going to do this again. So please keep your eye on the website, constitutionstudy.com/study, and find out when I'm going to bring up the new study and how you can participate. Most of all, this information doesn't exist in a vacuum. Most people find out about the Constitution study through word of mouth. So please spread this information far and wide. Friends, family, social media, wherever you can. Let them know about this voice talking about the Constitution, what it actually says. Bring them along as we continue this journey of education to learn about this wonderful document and how we can use it to protect our own rights. Most of all, join the cause. Join the movement that says, we will secure the blessings of liberty. We won't wait around for someone else to do it for us. Now, if you found this useful and you're willing to share, well, bring some friends and join me right here next time for the Constitution Study.